Happy Monday, and welcome to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. Today we're talking about dangerous offenders. Cases that should have gone to the Supreme Court of Canada, but didn't. Gordon Nickerson was an Indigenous individual who was subject to a dangerous offender hearing. In the course of the dangerous offender hearing, the psychiatric experts who were called had access to certain documents that were retrieved from his computer without his ability to challenge the search of the computer for those documents. Although the dangerous offender hearing has constitutional protections, he was not able to bring an application to the court to exclude that evidence on the basis that it was unlawfully obtained, or have the court look into whether or not that evidence was unlawfully obtained. Ultimately, he appealed his case, attempting to seek leave from the Supreme Court of Canada, arguing that the method of obtaining the medical evidence, or the basis of the medical opinion evidence, was unlawful, and that the court erred in not permitting him to challenge the search. The Supreme Court of Canada denied the application. And this case raises very important issues, because a dangerous offender hearing is a proceeding like any other type of proceeding in court. It relies on evidence, and if the evidence that's relied on is obtained in an unlawful way, the state shouldn't have the benefit of it. But at the same time, a dangerous offender hearing is not like a normal trial in the sense that a court is determining the truth of matters, but rather making a designation about an individual which is being made ostensibly for the purposes of the protection of the public. And so to balance the charter-protected rights of an individual between the importance of evidence that may have been obtained unlawfully but may speak to the very real danger that somebody may pose to the public is an important issue that the Supreme Court of Canada needed to weigh in on. The finite balance between these charter-protected rights and the need to protect the public in the context of a dangerous offender hearing, as opposed to in the context of a criminal trial where innocence is presumed to begin with, as opposed to somebody who has convictions that have then led to the Crown seeking this designation, is very different. And the applicability of a Section 24(2) analysis in that context and what steps should be used by a court if a charter challenge could be brought in that context are all things the Supreme Court of Canada needs to define and needs to weigh in on. Lately, the Supreme Court of Canada has not said very much about search and seizure, and this is the type of case that ought to have grabbed its attention as an opportunity to really clarify and really sort of restate the law in relation to search and seizure, particularly in light of these applications that have such significant importance because of their lifelong lasting impact on an individual. Unfortunately, it's going to take another case where potentially unlawfully obtained evidence is being used to create a lifelong, life-altering designation for an individual before the Supreme Court of Canada has the opportunity to really divulge how judges should be looking at these issues when they come up in the context of dangerous offender applications. Cases that should have gone to the Supreme Court of Canada, but didn't. Thank you for tuning in to another episode of Cases That Should Have Gone to the Supreme Court of Canada but Didn't. I'm Kyla Lee at Acumen Law. Thank you to Brazen Bull Creative for putting together these videos. Please like, subscribe, and share with your friends.